As of yesterday, the 1st of July, of course, the Protection of Personal Information Act, or POPI, came into effect. Property management company Trafalgar says that community housing schemes need to urgently appoint official information officers to ensure that they are registered with the information regulator. Trafalgar Managing Director, it's MD Andrew Schaefer, joining me now to explain what this actually means for complexes and estates. Andrew, good morning to you. There you are. So I've seen all the WhatsApp groups. I've got friends who live in complexes, as we all do. There's quite a lot of confusion about what this POPI Act means for complexes and housing estates, whatever term you want to use, regarding WhatsApp groups, CCTV cameras, signing in and out of guests and visitors. We'll talk a bit about the information officer in a moment, but can you just unpack what these changes mean for complexes and secure estates?
All right, good morning. Thank you very much, and to your listeners. Yes, so community schemes are typically juristic entities, so they are therefore required to have an information officer registered and to be compliant as well. So that's the first thing. Unfortunately, we're finding a lot of our community scheme trustees and directors fixate on the huge fines that are referenced in the legislation, and they, naturally are very anxious and very concerned because they don't have a good grasp on the legislation typically, and also feel that they aren't in full control of the community scheme personal information, much of which is sitting with the managing agent at the moment. The information regulator has published a guideline saying that the managing agent may not currently be the information officer, which we have asked the chief ombud, the CSOS chief ombud, to try and escalate and see if that can be revisited. But for now, there is required to be a registered information officer with the community scheme, which should be either the chairman by default or a trustee director who would be, a senior executive and therefore able to control and influence the way that the personal information is protected and managed. And we're talking about owners, contact details, their financial information, and obviously with biometrics and CCTVs, there's fingerprints and images on record as well. So it's that personal information which does need to be protected in terms of the legislation. And, it can be done with reasonable safeguards and reasonable, efforts, which many managing agents are well equipped to advise and support. In many ways, the protection can be outsourced to the managing agent through a data processing agreement, which then assigns accountability. But at the end of the day, it is the registered information officer that is accountable and on record with the information regulator.
All right, so right now, as of yesterday, what needs to change quite quickly to handle everything you just spoke about, Andrew, is an information officer, if there isn't one already, has to be appointed. If I live in a complex, let's say I'm an owner or I'm renting, what do I need to do different as of yesterday? Am I allowed to ask the complex, the estate that I live in, to remove my information? Am I, as an owner or a tenant, obliged to hand over my information? Just talk to those who are sitting at home right now, Andrew, and what they might not understand, what it means for an owner/tenant. What do I have to do as of yesterday?
Right. Well, I mean, the legislation provides for any owner, anybody, to request what personal information is currently on record with the managing agent, for example. So there's a prescribed form that could be sent through to the managing agent, and they would be required to provide a report of what exact personal information they do have on record, and why it's on record and how it's processed. So that's the first comment. The managing agent would require to process that information in terms of billing monthly levies. In the case of tenants, it's rentals, and collecting those levies for purposes of paying the creditors to maintain services at the community scheme. So the legislation does provide for personal information to be collected and processed where stipulated in other legislation. So, for example, in the Sectional Title Schemes Management Act, it does provide for the personal information to be collected and stored by the managing agent, because it's got obvious administration requirements and purposes. Otherwise, the scheme would not be able to function in terms of billing and levy income and service delivery and paying creditors, etc. So, one does need to be realistic and understand that there is other applicable legislation which does provide for that personal information, to be used in a particular way for a particular purpose, in line with the example I mentioned. But certainly owners and tenants would be able to see what personal information is on record, to understand why it's on record and how it's processed. And if they, for example, did sell and leave a community scheme, they would be able to, request that their personal information is deleted and achieve confirmation of that.
That's some very important information. I think it's exactly what those living in complexes, estates, and I think you call them community schemes, are worried about. So as of yesterday, that's what you need to be doing. If you're watching Andrew, Schaefer, and I, that's what you need to be doing as of yesterday. What a pleasure, Andrew. Thanks for clarifying. Trafalgar Managing Director Andrew Schaefer joining us here on eNCA.